Hello viewers, how are you? I hope you have watched the previous video related to free consent and undue influence. In this video also some more aspects related to undue influence are covered. So a contract is said to be induced by undue influence when the relationship between the parties is such that one of the parties is in a dominating position. It uses its position and obtains some unreasonable advantage over the other. Now, in this video, I will be covering the points related to pleadings, the evidence when a person is pleading undue influence, the points which the court has to consider or the court should consider, and who can plea undue influence and what will be the effect if a third party has used undue influence, and the Unidroit principles. Okay. So while pleading, it is necessary that all the points should be pleaded when a person is saying undue influence has been used. So he should specify all the things that what actually was the nature of the influence, how it was exercised, what unreasonable advantage has been taken. So all these points should be pleaded properly. Then what is the evidence of undue influence? So the person who's pleading undue influence has to show that there is a substantial relationship, means there is such a relationship that the person is in a position to dominate the will, the other person is in a position to dominate the will, maybe due to the closeness of relationship, or maybe because of the custody, or due to the circumstances, and that the person has obtained some unreasonable advantage. किसी ने कहा अनड्यू इन्फ्लुएंस का इस्तेमाल हो गया और कोर्ट मान लेगा, ऐसा तो नहीं होगा ना, उसके लिए एविडेंस चाहिएगा. तो सर्कमस्टांसेस अलग अलग रह सकते हैं, प्रिंसिपल्स तो सेम ही रहेंगे हर जगह पे. और प्रिंसिपल्स क्या हैं कि रिलेशनशिप दो लोगों के बीच में, और कोई अनरीजनेबल उस पोजीशन का, उस रिलेशनशिप का डोमिनेंस का इस्तेमाल करके अनरीजनेबल एडवांटेज लिया गया है. अब जब ये होता है तो क्या, what are the things that a person is considering, that whether the claimer or whether the person who's getting the benefit was in a position to claim it, means did he have that right, whether due to the nature or some moral claim, did the gainer have some right, and did the grantor or the performer of the contract, or the person who has entered into the contract, or the giver or the donor was in a rationally he has decided, and if he would have really been willing to do it. Okay, so this is the thing where doubt can be raised related to undue influence. Inadequacy of contract per se does not give rise to undue influence, but yes, from inadequacy of contract inadequacy of consideration, an inference can be drawn that did the person properly understand the contract, or was he in the proper state of mind, and was he having full control over his mind. So these are the things, and along with these things the other points will also be taken into consideration as to indebtedness, illiteracy, or other factors. Okay, independent advice, and all these things collectively, from all these evidences collectively, the inference will be drawn about, or the evidence will be given for undue influence. Now when this question arises that undue influence has been used, so what are the points which the court should consider? The first thing is that it is a righteous thing. Is it a righteous thing? मतलब यदि आप प्रॉपरली रैशनली यदि सोचते हैं तो क्या कोई व्यक्ति ऐसा काम कर सकता है, फर्स्ट थिंग. Second thing, that if it is a thoughtless, whether it was a thoughtless act, and the thoughtlessness has been to such a great extent that it gives rise to a doubt कि जिस व्यक्ति ने ये काम किया है शायद वो अपने प्रॉपर स्टेट ऑफ माइंड में ही नहीं था, या उसे वो फ्रीडम ही नहीं हो कि वो डिसीजन कुछ और डिसीजन ले सके. And the third thing is whether an independent legal advisor was needed. Okay. And the fourth thing which the court should consider is that whether the person who gave or the donor this idea of donating or this idea of entering into the contract originated from the doer or from the donor. Okay. So these are the things which the court should consider when there is any question of undue influence. Then who can plea undue influence? So obviously the party to the contract who is the executant or his legal higher can plea undue influence. It is like a third person cannot plea undue influence. Okay. But yes, when a contract is entered into between two persons, one of the parties can set aside the contract on the ground that the third person has obtained the consent using the second person has obtained the consent by using undue influence through a third person. Third person means a third party means a person who is not a party to the contract. तो ऐसा हो सकता है कि कोई कॉन्ट्रैक्ट को असाइड रख दिया जाए, मतलब अलग रख दिया जाए, या उसको voidable contract में convert किया जाए on the ground कि though the party to the contract did not use undue influence but it induced the third person or to use this undue influence and the consent was obtained. तो ये कब कब हो सकता है कि जैसे थर्ड पर्सन के बोलने पे ये कॉन्ट्रैक्ट, मतलब थर्ड पर्सन ने प्रेशराइज किया ये कॉन्ट्रैक्ट करने के लिए, या द अदर पर्सन A and B have entered into the contract. B is the agent of the third person and the third person is using that position over A and making A to enter into the contract with B, or the third person is the principal and he is not directly entering into the contract with A but he is using his relationship and making A enter into the contract with B, or the third person has means the other person has given some consideration to the third party. मतलब A को consent, A की consent मिलनी चाहिए इस contract के लिए, इसलिए B ने C को कोई consideration दे दिया है, क्योंकि B जानता है कि C और A के बीच में म्यूचुअल ट्रस्ट फिड्यूशियरी रिलेशनशिप है और उस चीज़ का बेनिफिट भी लेना चाहता है, तो उसने कुछ कंसिडरेशन दे दिया है C को, ताकि C A को ये कॉन्टैक्ट करने के लिए इंस्टिगेट करे या प्रमोट करे, या A को ऐसा डाउट होता है कि B and C have conspired, there is some conspiracy and C is using this pressure on A to enter into this contract. In this situation, A can set aside the contract. A contract को अलग, मतलब वो क्या बोलेंगे, voidable contract में convert कर सकता है. Then we come to the principle, Unidroit principles. Article 3.10 says that कभी भी किसी भी कॉन्ट्रैक्ट में यदि ये लगता है कि एक पार्टी के साथ बहुत ज़्यादा, मतलब दूसरी पार्टी ने बहुत ज़्यादा उसको एक्सप्लॉइट किया है या ये कॉन्ट्रैक्ट की वजह से बहुत ज़्यादा उसके ऊपर हार्डशिप्स आ रही हैं, तो कभी भी वो कॉन्ट्रैक्ट को तोड़ा जा सकता है. सो आई होप you have understood the things properly. If you have any query, you can definitely state the things in the comment section. I'm thankful to all my subscribers who have pressed the bell icon so that they get the notification as soon as I upload the video. I'm also very much thankful to the new subscribers who will be subscribing and pressing the bell icon so that they also get the notification as soon as a new video is uploaded. And I'll really appreciate your efforts in sharing the video with your friends and anyone who is pursuing the studies related to Indian Contract Act. This Indian Contract Act is useful for the studies of mercantile law, business law, for MBA students, for CA students, CS students, CMA students, So kindly share the video with your friends. Stay tuned. Happy learning. Bye bye.